Good afternoon. My name is George Parnham. I am a criminal defense lawyer, board certified by the Board of Legal Specialization. I have been practicing criminal defense law, both federal and state, for over 51 years, and enjoy what I do and hope I can do it for another 50. Today we are going to talk about an issue that is frequently in the news and certainly something that raises issues in the courtroom, and that is a search without a warrant. A law enforcement officer issues a search and doesn't have a warrant to do so. Now, Article 1, Section 9, as well as the Fourth Amendment to the Constitution of the United States basically prescribes that warrantless searches are unreasonable in and of themselves, and therefore can be subjected to a motion to quash as far as the extent of the search is concerned and the evidence obtained as a result of an unreasonable search. There are obviously some exceptions, and we'll talk a little bit about the exceptions in general, and then I will turn it over to my associate, Tom Abbate, who will talk in great length about the circumstances that comprise exigent circumstances, that is, circumstances that permit a search without a warrant. One such, of course, is the fact that if an officer is involved and sees an offense taking place at that time, it would be very impractical for the officer to go and obtain a search warrant. It takes time to do that, and as a consequence, the activity of a criminal nature may be over and the suspected defendant gone. That is an exigent circumstance, which probably is the most vital and of the exigent circumstances that Tom will talk about with you later.
Tom Abbate, and today we're going to talk about exceptions to the warrant requirement. Now, generally under the Fourth Amendment, law enforcement needs a warrant in order to either arrest or search a person, place, or thing. However, there are certain exceptions to this. For instance, when it comes to the person, if the officer witnesses you committing the crime, and then as you flee from him, he no longer needs a warrant to go and arrest you. If, something is reported to him very near in time, like, for instance, you're shoplifting at the store, you walk out of the store, the officer didn't witness you shoplifting, but the clerk comes out and points at you and says, he just stole my stuff. The officer now potentially has grounds to come and arrest you. He's at least got a reasonable suspicion. If, he pats you down and finds the things that were taken from the store, then obviously he's going to have all the grounds he needs to arrest you for the theft. With searches, it becomes a little bit different because there's a lot more exceptions to that warrant requirement. First of all, flight from a crime is still going to be covered. If the officer sees you, say you just robbed a bank and you're fleeing and you run into your house, normally the officer would need a warrant to go into the house to look for you, but because he was chasing you down, the law does not require that he go and get a warrant because you may potentially escape. So that's one of the first exceptions, and that's under what we call exigent circumstances. which is a flight from a commission of a crime. Other exigent circumstances are going to be things such as if the officers believe that the evidence is in imminent danger of being destroyed. So, for instance, let's say you're at a bar and you have cocaine on you. Someone reports to the officer that you have that cocaine. He starts walking towards you. You see him. You know what's up. You turn around, run into the bathroom so that you can start dumping it down the toilet and flushing it. Well, he doesn't need a warrant to follow you into that bathroom and to get a hold of you and, pat you down for the drugs, because there is an imminent danger that that evidence is going to be destroyed. The other exigent circumstance is whenever a person is in need of help and the officer reasonably believes such. So, for instance, if the cops come to your house and they knock on the door, no one comes to the door, but they hear screaming from inside, that is going to give them the exigent circumstances they need to kick open the door and make sure that no one inside is being harmed in any way. Now, these exigent circumstances can play into other exceptions that you need to be aware of as well. The biggest one, and one of the ones that comes up the most often, is the plain view exception. So under that example of, they hear screaming from inside the house, if the officers kick in the door, they find, someone laying there on the ground or listening to the movie too loud, whatever the case may be. But once they're inside the house and they see dope on the coffee table in the living room in plain view, they don't need a warrant for that to seize those drugs. Now, the plain view exception has some caveats to it in that the officer cannot manipulate anything at all while in the house. There's a very famous case where the defendant was alleged to have stolen a bunch of radio equipment. When the officers came in under a different exception, they noticed that he had all of these VCRs, yes, it's a very old case, stacked up with all the serial numbers pointing at the back wall. One of the officers turned the VCRs to get the serial numbers off the back. The court said, no, that's no longer under the plain view because you had to do more in order to determine that it was, stolen goods or contraband. It has to be immediately apparent and it has to be out in the open. So, make sure you put away any contraband that's laying out in your house. It's never a good idea to just leave it on the coffee table, because anytime an officer comes in, they don't need a warrant for that. The other big exception is going to be consent. If you or someone who has legal authority over the residence or place or thing consents to letting law enforcement search it, that's going to come in. And this is important because, maybe I own the house, I have a roommate that's staying with me, their name's not on any of the title, paperwork, taxes, any of that. If they answer the door and the officer asks if he can search the house and they say yes, that's everything they find in that house is going to come in, even though I am the legal owner of the house. This also works to some extent with, hotel rooms and things like that. It's whoever has the greater right of possession or a right of possession. But if you consent, it will come in. The third largest one is going to be officer safety. This is, where stop and frisk and pat downs come in. If the officer has a reasonable suspicion to, stop you and start questioning you, they have the right to at least pat you down for weapons. Now, other things can be found in a pat down. For instance, maybe I don't have a gun in my pocket, but I've got, a bag, a 1 pound bag of marijuana in my pocket. Well, when he pats me, he's going to see something, he's going to pull it out, and then now it's, immediately apparent what it is, so he doesn't need a warrant to have that seized, if that makes sense.